For more on Bank of America's change in strategy, we are joined right now on the phone by Jonathan Macey. He's a professor of corporate and securities law at Yale University. He's joining us from New Haven. Professor, glad to have you with us this morning. As we have been reporting, Bank of America changes the stance that it's held for 6 months, saying that it is no longer going to respect, if you like, this attorney-client privilege. It is going to disclose some of these legal briefs pertaining to the Merrill Lynch, Bank of America Merrill Lynch acquisition. What do you make of that, of the board changing its mind, of giving over these documents to the New York AG, also it seems like to the SEC?
Well, I think they decided it was an unsuccessful strategy. I also think that there's a chance that the board members who recently were interviewed by the Attorney General of New York, Andrew Cuomo, decided that they were taking too much heat personally, and maybe they are going to sell the company down the drain a little bit.
Because, I mean, the AG said that this attorney-client privilege was essentially blocking him in his investigation. Right.
That's a very common position for regulators to take. They say you're not cooperating if you don't. It's kind of a sleazy move, but they say if you don't waive the attorney-client privilege, we're going to deem you a non-cooperative and come down a lot harder on you than we would otherwise.
Have you ever seen this before?
Very common. That is to say, particular administrative agencies, particularly the Securities and Exchange Commission, often takes the position that companies should waive the attorney-client privilege. It's very much frowned upon, particularly by judges, but it happens.
One thing, Professor, that we haven't talked about, to what extent is the law firm Wachtell, Lipton, Rosen, and Katz, I mean, to what extent is that firm going to be put in the spotlight? We spoke to a professor from St. John's saying, listen, the revelation isn't going to be the substance of the advice. More than likely, it was cautious. But I'm just curious for your take on that.
Yeah, I agree with the St. John's guy. I think that there's a huge amount of speculation about this, and people are saying that that the advice from Wachtell was, you don't have to disclose this stuff. I think that's highly unlikely for a variety of reasons. Given the particular individuals involved in their style and reputation, it would be shocking, number one. Number two, if that were the case, Bank of America would have disclosed this stuff a long time ago. So I think it's far more likely that the advice was exceptionally cautious, and which is exactly why B of A hasn't wanted to disclose it, because it puts them in a rather bad light. I think the law firm will come out smelling like a rose.
Okay. We thank you so much, Professor Macey, joining us there from Yale University.